Order, order. Afternoon, ladies and gentlemen. Jamie Soane to move the motion, please.
Thank you very much, Sir Roger. It's always a pleasure to serve under your chairmanship. I beg to move that this House has considered E-petition 728715 relating to reviewing possible penalties for social media posts, including the use of prison. Now, as chair of the Petitions Committee, I'd first like to say that it is always encouraging to witness public participation in politics. And with over 100,000 signatures, it is evident that this petition has engaged a large number of people all across the country. Now, this E-petition was created by one of my fellow members of the House of Commons, the Honourable Member for Great Yarmouth. And, Sir Roger, this is the first time ever an elected member has used the E-petition system in this way to garner enough support to secure a debate, making this a unique instance, I would suggest. He explained to me that he believes that this government has taken a two-tier approach to policing, which needs to be urgently reviewed. When I use the phrase two-tier, I'm referring to the belief that police in this country are overtly lenient towards protesters of progressive causes and racial minority protesters compared to others. To put it simply, those who subscribe to this criticism of our justice system do not believe that citizens are being punished fairly or impartially. That is why the signatories to this petition believe the system needs to be reviewed. Specifically, they're calling on the government to urgently review the possible penalties for non-violent offences arising from social media posts, including the use of prison. During our meeting, the member for Great Yarmouth explained that when it comes to punishing an individual for something they post on a social media platform, it is his belief that previous sentences issued for offences under this government have risked encroaching on the individual liberty of a defendant, in particular their freedom of speech. Now, I would suggest that freedom of expression has always been a cornerstone of our democracy. In this country, in the UK, people are free to demonstrate their views regardless of any discomfort caused to the majority. However, the freedom to express these opinions does not exempt any criminal motivation behind them from being prosecuted. Just as we're a country that takes pride in our citizens' liberties and freedoms, we're also a nation that takes pride in a criminal justice system that protects our citizens from harm. The former will never, Sir Roger, I suggest, override the latter. Under Section 22 of the UK's current Online Safety Act 2023, a statutory duty to consider free expression protects the rights of users within the law. Crucially, the Act explicitly defines, and I quote, freedom of expression, close quotes, in terms compatible with the European Convention on Human Rights. That is the right, again in quotes, to receive and impart ideas, opinions or information by means of speech, writing or images, close quotes. However, Section 59 of the same Act makes it clear that the boundary of this freedom only extends as far as the legality of the content. In other words, content isn't just judged by whether it is unpopular, offensive or controversial, but whether, crucially, it violates criminal law. Examples of such violations include types of intimate image abuse, harassment, or the incitement of hate crimes, to name but a few. Now, this brings us to the question of criminality and prosecution for such an offence, I believe the very crux of this petition. When I spoke to the Sentencing Council, they made it clear to me that intent matters a lot in many of these offences. The Sentencing Council's definition of intent ranges from the highest culpability for a deliberate intention to cause harm to lower levels of culpability for recklessness, knowledge of risk, or sheer negligence. The Council considers an offender's intent to be a key factor in determining the seriousness of an offence and the appropriate sentence, which will often be based on the level of harm that was intended, even if it was not actually caused. In our modern age of social media, where communication is instant, rapid and far-reaching, the question of culpability, intent and widespread dissemination does indeed hold serious weight. It is reasonable, I think, to assume all citizens realise this when using sites such as X, Instagram or Facebook. When it comes to calling on the government to review the possible penalties for non-violent offences, arising from social media posts, it is absolutely imperative to clarify the particulars of existing sentencing guidelines. In the UK, in our country, the government cannot simply change criminal penalties on its own. This is because the power to set or alter penalties is controlled by Parliament and the courts, not by ministers. Any change to the maximum or minimum penalty for an offence must be made through primary legislation, which means a new law or amendment has to pass through the full parliamentary process, drafting, scrutiny and debate, and of course approval by both houses, the Commons and the House of Lords. The government may indeed propose changes, but it absolutely cannot impose them without Parliament voting them into law. Even after Parliament sets the legal penalty ranges, the government still cannot decide individual sentences, because sentences are often carried out independently by judges, who must follow the Sentencing Council's guidelines, absolutely not the preferences of ministers. The government also cannot order judges to give harsher or more lenient sentences in specific cases, because, as we know, judicial independence protects courts from political interference. It is indeed, I would suggest, a crucial pillar in our political system and in our justice system. Neither the courts nor Parliament stand alone. This ensures balanced decisions are made independently within the public interest. Now, all of this is seriously complex and is a question that addresses a large scale of harm and, in some cases, prejudice. This is to say, I'm absolutely certain my colleagues will debate it this evening, Sir Roger, with respect, rationale and indeed nuance. I can see I've got lots of colleagues here hoping to speak today, and I will bring my remarks to a close, allowing as many as possible to participate. Thank you, Sir Roger.
The question is that this House has considered E-petition 728715 relating to penalties for offences arising from social media posts. I suspect, because there appear to be other attractions in the main chamber today, a number of members who'd indicated they wish to participate are not present. And for that reason, I have no need, I think, to put any time limit on contributions. Emily Darlington.
Thank you. It is a pleasure to serve under your chairship, Sir Roger Gale. The first duty of government is to keep its citizens safe. We do that with the police, our court system, and while not perfect, we couldn't do it without them. The online space is an integral part of our modern lives, and we need to treat it as such, because what happens online does not stay online. Online safety naysayers want you to think that regulating the online space is a conspiracy to end freedom of speech. Some, like the member of Clacton, say that while his online try to make that case, while his online followers send women and minorities death and rape threats when we speak freely, including to members from this House. Like many women MPs, I receive at least one of these a week. Rather than take away free speech and democracy, what we're doing is ensuring that everybody has a voice, so that people, including the alleged victims of Andrew and Tristan Tate, can one day have an online profile again, without getting their home addresses splashed all over the internet and being doxed, as young people like to call it. Democracy should be about ideas and debates, yet the online environment that some members of this House want is one where you can make deep fakes, misleading the electorate, where you can threaten women with rape to shut them up when you don't agree with them, where you can make £300,000 by making 128 Facebook pages spreading racist and AI-generated misinformation, which is then amplified by members of the Reform Party, monetizing hate, as the Piece and the Times exposed this morning. So, actually, without extending our election laws to online spaces, single platforms or platform owners with specific political or financial agendas can continue to spread lies and misinformation, even going so far as to incite violence in another country. That is not democracy, that is not free speech, and it is up to this government to ward against it and ensure that our laws and our sentencing is appropriate. As I said, the first duty of any government is to keep its citizens safe. In real life, a 12-year-old can't go see a film at a cinema if it's rated 15. Pornography is put on the top shelf at the newsagents, out of reach. Kids can't buy a video game that is adult-only rated without ID. But online, our kids can find any kind of graphic or sexual content of any level of extremity as easily as texting their friends. The Online Safety Act is there to protect everyone. It's there to put porn back on the top shelf and out of reach of kids. It works to stop a 10-year-old from finding graphic depictions of violence and of being encouraged to become violent themselves or being groomed as strangers. So to those that want to scrap the Online Safety Act and the sentencing that goes along with it, they are actually putting our free speech, those who are intimidated every day for trying to say their own views online, and even more so, put our democracy at risk. So let's bring common sense back and let's protect this country. Thank you.
As the honourable gentleman, the member for Caithness, Sutherland and Easter Ross said in his opening remarks, this is the first time that a debate has been instigated, an E-petition debate has been instigated by a member of this House. So it gives me great pleasure to call the culprit, Rupert Lowe.
Well, thank you, Sir Roger. It's a pleasure to serve under your chairmanship. And I'm grateful to the Petitions Committee for granting time for this extremely important debate following our successful petition. Most importantly, I want to thank the more than 190,000 British people who signed the petition that we initiated, calling for an end to the creeping use of prison as a punishment for what people say online. We wouldn't be sitting here today without their support. I think that pays credit to this petition system, one of the better functioning arms of Parliament. I want to begin by welcoming Lucy Connolly and her husband who are here today. She is one of the many ordinary citizens who's been swept up in the chaotic and inconsistent enforcement of our online speech laws. Her courage in speaking openly about her experience has helped expose a growing problem, namely that the British state is now more willing to imprison somebody for a social media post than for a rape. That is not justice. That is not proportionate. That is certainly not the mark of a free country. I will give way.
And I do thank you for bringing this petition to this committee. Can you cite what analysis he bases that comment on about people being more likely to be in prison for a social media tweet than rape?
I'm sure the honourable gentleman has heard of the Pakistani rape gangs, which are currently the subject of my crowdfunder. And when you read the report that is coming out in March, I'm sure you'll agree with me. We are witnessing the steady expansion of what are essentially speech crimes, offences where there is no violence, no real threat of violence, and often no identifiable victim at all. Yet people are facing dawn raids, criminal records, ankle tags, and even lengthy prison sentences for words, for arguments, for opinions that somebody somewhere claims to find offensive. I have my own personal experience. A late-night police raid initiated by false allegations from former Reform Party colleagues relating solely to words I had allegedly spoken. The party of free speech, indeed. The Reform leadership's bitter attempt to see me in prison failed, but too many others do not escape the consequences of such vile misuse of the system. We now have laws being used to punish subjective offence based on the most fragile interpretation of harm, enforced through discretionary and far too often politically skewed policing. A post that is deemed sharp criticism 1 month somehow becomes grossly offensive the next. It is arbitrary, it is inconsistent, and it is fundamentally incompatible with a healthy democracy. I receive multiple death threats, yet the police take no action. Just one example. Online influencer Shola Mos Shogbamimu recently posted on X, and I quote, "I am against the death penalty, but for you, Rupert Lowe, I'll gladly make the exception." This post currently has 2 million views. The Met Police have said no action will be taken. I don't want people in prison for social media posts. I also don't want such obvious two-tier policing. Shola walks free, yet Lucy Connolly was imprisoned for one foolish social media post, soon deleted. Where is the fairness in that? If these ludicrous laws are to be implemented, then it must be done fairly, with no political bias. Evidently, that is not currently happening. Is our prison system so efficient, so functional, so unoccupied that we have the capacity to put a young mother like Lucy in prison for more than 300 days? I think not. When rapists and murderers are walking free, even being released early, there is zero justification for imprisoning Lucy and the many others like her, particularly when the influence of such questionable legal aid is so heavily involved. We must be clear. No free society can survive with a people afraid to speak. Democracy depends on robust argument, dissent, and the ability to challenge orthodoxy. As George Orwell so presciently stated, if liberty means anything at all, it means the right to tell people what they do not want to hear. Parliament needs to draw a deep line in the sand. In Britain, nobody should ever be sent to prison for an offensive social media post, full stop. That requires legislative reform. We need clearer thresholds in law, a robust statutory requirement that prosecutorial decisions consider freedom of expression, and a prohibition on custodial sentences for pure speech cases. The poison of two-tier justice must be forensically extracted from our judicial system. This debate is not about whether we are prepared to live in a country where liberty exists only for those who never cause offence, an impossible and undesirable standard. To Lucy and to every other person who has found themselves dragged through the system for a post online, you deserve better from your government, and I sincerely hope today marks the beginning of a serious rethink in this House. Thank you.
Richard Quigley.
Thank you, Sir Roger, and it'll come as no surprise to what a pleasure it is to serve under your chairship. I want to be transparent. I do not believe the law has always got it right in these cases. There have been failures and there must be room for scrutiny and reform. But I'm compelled to speak today because of the hypocrisy and double standards perpetuated by many on the opposition benches. Those who brand themselves as defenders of free speech yet seem to confuse freedom of speech and freedom from consequence. Something I taught my children from being very young is this: you are free to use your words, but you must be prepared to face the consequences of them. You may think that writing an offensive post, something that takes only several seconds and is quickly forgotten, is inconsequential. But as we've seen over the past year and in recent months, especially, such words can have devastating effects. They can fuel radicalisation, they can target minority communities, they can make individuals feel unsafe in their own homes, schools and streets. And while some demand the right to speak without restraint, they ignore the reality that others lose their freedom to live without fear. A freedom hard fought for by those we pay tribute to on Armistice Day. I find it genuinely astounding that the parties such as Reform UK and many in today's Conservative Party espouse the importance of personal responsibility and accountability, yet are fundamentally unable to stomach it when individuals on their side of the political argument are held accountable for their words. My personal position, and I think the position of many of my colleagues on this side of the chamber, is clear. Hate speech is hate speech. Words have consequences, and no matter if I passionately disagree with you politically, if someone uses social media to call for the death or harm of another, they should be held accountable by any means the law deems fit. Regrettably, I do not believe that the same clarity exists on the benches opposite. It's been astonishing to watch some members tie themselves in knots, on the one hand decrying Britain under Labour as a return to Soviet-style communism, while on the other demanding the removal of the Oxford Union President-elect for comments made in a private group chat, not social media. It seems that for the right wing, free speech is not a two-way street. It's Schrodinger's version of free speech. No more has this hypocrisy and knot tying been clearer than the case of the member for Clacton, who rightly disavowed and welcomed the imprisonment of an individual who used social media to threaten his life, but readily platformed a woman during his party conference who said, and I quote, "Mass deportation now, set fire to all the fucking hotels full of the bastards for all I care. If that makes me a racist, so be it." I'm genuinely intrigued as to whether free speech is only deemed acceptable if it is used to threaten the lives of refugees, but not the Reform Party leader. My point is this. No. My point is this. It is completely wrong to call for the death of the member for Clacton, just as it is completely wrong to call for hotels housing refugees to be burned down. In both cases, the law rightly intervened and justice was served. What is deeply concerning, however, is the warped suggestion that the law should be applied differently depending on who says something rather than what is said. That is not justice. It is politicisation. Our legal professionals are not the enemy. Our justice system, widely regarded as one of the foundational models of fairness and due process, is not the enemy. And our police, who enforce the law but do not create it, are not the enemy either. We must defend the principle that the law applies equally to all, regardless of political affiliation, background or platform. That should not be controversial. It is, in fact, one of the oldest principles in our democracy. The Magna Carta, the cornerstone of our unwritten constitution, states, "To no one will we sell, to no one will we deny or delay right or justice." That commitment to fairness and equality before the law is not just historical, it is foundational. Ultimately, if we in this Parliament believe the law needs to change, we have the power and the responsibility to do so through proper democratic process. But those who seek to twist justice, who argue that the law should be applied differently, depending on who says something rather than what is said, should ask, are they defending the spirit of British democracy, or are they defending a warped version of it shaped not by principle, but by popularity on X? Thank you, Chair.
Well done.
Pleasure to serve under your chairmanship. Freedom of speech is a vital right, but it must end where harm to another begins. Online freedom cannot mean freedom to exploit, to encourage self-harm, or destroy lives. And I appreciate that I'm taking this in slightly off-piece direction, but it is relevant in relation to the debate we are having today. And that is because suicide forums and other user-to-user platforms are also part of what Ofcom count as social media. If this debate is about the proportionality of penalties applied to offences arising from social media posts, then we must address the stark reality that the most harmful content online is actually the least likely to attract enforcement. And nowhere is this clearer than the unrelated suicide forums, which the Telegraph recently described as a terrifying online world where users share methods, encourage one another to die and prey on the vulnerable. The Molly Rose Foundation, founded by bereaved parents after losing their daughter Molly, has exposed the scale of this threat. Their report, Missed Chances, Lost Lives, links at least 133 UK deaths to a single pro-suicide forum which operates overseas. On this site, young people, many just teenagers, are encouraged, instructed and groomed into taking their own lives. The forum hosts detailed methods, promotes poisonous substances, shares advice on bypassing UK regulations, and even enables suicide pacts between strangers, which facilitates the abuse of vulnerable women. This is not free speech. As the site moderators claim, it is the deliberate facilitation of harm, fatal harm. I first became aware of the Foundation's work when I met a local family who lost their daughter, Hannah. She'd been on that forum where she found links to poisons and guidance on how to obtain them outside the UK restrictions. Her father, Pete, warned me that harm is out there waiting to be found by teenagers. No parent should ever have to bury their child because of an unregulated user-to-user forum or social media. What makes this even harder to accept is how many mischances there have been to act. Coroners have issued 65 prevention of future death reports to 3 government bodies, 65 formal warnings that the site and its content were putting people at risk. Had those warnings triggered action when they should have, many of those 133 people may still be with us today. Ofcom eventually opened a formal investigation under the Online Safety Act, but only in 2025, long after families began sounding the alarm. Its own letter acknowledges serious risks of harm to UK users, including children, yet despite this, Ofcom initially accepted a voluntary geo-block that could be easily bypassed with a simple VPN. It took the discovery of a mirror site and determined unrelenting pressure from bereaved families for Ofcom to escalate the case to priority. Chair, this goes to the heart of today's debate. If we're examining how penalties are applied for offences arising from social media, then we must ask why the quickest and toughest enforcement does not fall on those creating the greatest real-world harm. The Online Safety Act creates strong penalties for encouraging suicide and serious self-harm, penalties of up to 14 years and 5 years in prison. These penalties must not be weakened. They must be used, and they must be supported by regulators who treat the loss of life due to online harms with urgency it demands. I've met too many parents, siblings and friends and loved ones whose lives have been shattered. Their message is simple: protect young people, target the real harms and use the penalties to save lives. If proportionality, Chair, is the principle, then let it be proportional to harm, because our young people deserve a system that protects them, not the one that leaves the deadliest corners of the internet untouched. So I thank the Honourable Member in part for his debate today, for enabling me to raise this part of the important conversation relating to penalties for offences arising from social media and user-to-user platforms. Thank you, Sir Roger.
Mr. Scott Arthur.
Thank you, Chair, and what a pleasure it is to serve under you. And I'd like to thank the member for Sutherland and Easter Ross for so ably introducing this debate. And although I think she described her speech as being a little bit off-piste, I do want to thank the member for Guildford for raising that really important subject, and you're always welcome to raise it in any debate I am part of. Mr Chair, the only two-tier justice system I know in the UK is between the rich and the poor, and between the powerful and the powerless. And that's why I'm so pleased we were able to introduce the Hillsborough Law. And I also have to say, what we're not talking about here is posts which are a result of a difference of political opinion, whether rail should be nationalised or not, or whether or not we should invest more money in the NHS. What we're talking about here are posts which contain elements of racial hatred, which is completely unacceptable and isn't a political issue, unless we're arguing that somehow racial hatred is a political philosophy. Last summer, we saw tragic violence right across the UK. And I think Edinburgh was only spared from it through the hard work over many years of the Edinburgh Interrail Forum. We saw British people attacked because of the faith or the colour of their skin. Utterly reprehensible, Mr Chair. And I do know I spoke to parents at the time who were worried about their children going to school of all ages, their children of all ages, some going to school, some going to work. It was a horrendous time. And this violence was being amplified and accelerated online. Many of those carrying out these violent acts argued that their actions were solely in response to the tragic events that occurred in Southport. But it's clear that the level of fury we witnessed was encouraged by online instigators. These instigators stirred racial tensions and spread false information before the public had a true and complete understanding of what had occurred that awful day. Just like we've seen a couple of weekends ago after the attack on the LNER train. People online were quick to link that to immigration and also Islam as well, which I found utterly unbelievable. But when the statement came to the House of Commons, by then we knew there was no link to immigration or Islam, so there was no Reform MPs in the chamber to talk about it. Utter disgrace. As MPs, we all have had our fair share of online abuse and unpleasant comments, and I do recognise the point made earlier about women attracting much more of that abuse than men do. I absolutely recognise that. And we know that the internet is a challenging and complex place. However, when posts tip over into threatening communications, inciting violence against specific groups of people, there must be provisions in place for prosecution. Members opposite argue that prison sentences are being given for comments that were maybe mistaken or intended as humorous. But we know some of the people who were in prison, Chair, this was merely one of many racially motivated comments they made over a period of time. They call these posts foolish, clumsy or misunderstood, yet many of the people actually pled guilty to inciting racial hatred. But let's be clear, the posts that led to prosecution were an incitement of violence and outright racial hatred, and that is why those people did plead guilty. The CPS is clear that the state must act when there is a clear threat to public order and safety, online or in the real world. And online, after all, employment law still applies. We can't, thankfully, we've got procedures in place to protect children from online harm. Fraud is still a crime online. Defamation of character is still a crime online. So I don't understand why people are arguing that racially motivated hatred should not be a law online when it is in the real world. Why should we be able to say something online that we wouldn't say in the pub? It's utterly unbelievable that people are putting forward this argument. It's unacceptable. And it is right that this applies across our society. The recent case of a man in prison for making threats to the honourable member for Clacton shows that our judiciary acts when faced with criminal online threats of violence. And does anybody want to say they're opposed to that particular gentleman being in jail for 5 years? Of course they don't. Freedom of speech is central to our democracy. I understand the stretched resources that face all of our police forces, but inciting violence on our streets against vulnerable people can never go unchallenged, whether it be online or in person. Thank you, Chair.
Liberal Democrat Front Bench spokesperson Luke Taylor.
Thank you, Sir Roger. It is a pleasure to serve under your chairship, as always. The text of this petition makes specific reference to posts on social media, as if this modern medium is somehow separate from every form of speech that came before it. Social media posts take seconds to write and publish, and then they're everywhere. They're seen by your parents, your grandparents, and your kids, with no fact check, no filter. Terrifyingly, a 2025 Ofcom study found that 3/4 of 18 to 24-year-olds use digital platforms and social media to get their news. The sort of reach once available to only professional journalists, filtered through editors and media owners, is now available to anyone with a phone. You can post with a moment's thought during your morning coffee break with the same ease that world leaders with armies of speechwriters and fact-checkers and lawyers would craft their statements. One impulsive tap on an app can land in the lap or in the timelines of tens, thousands, millions of people. But let's be honest, who hasn't posted online something they later regretted? I know I have, and I challenge anyone these days to have an unblemished record online. But the incredible reach that modern social media has enabled, when compared to the guardianship and control of legacy media sources for centuries, has rightly been compared to the unleashing of the evils of the world from Pandora's box. We must recognise that attempting to reverse that exodus is as futile for us as it was for Pandora of myth. And keeping with historical allusions, the Sword of Damocles was the story that described how a single hair of a horse's tail held a sword over the head of King Dionysius, threatening to take away all that he enjoyed as a king without notice. A second's misplaced rage or a misjudged reaction to somebody else's message can cause that thread to break and for the sword to fall, for nationwide media to be sent to your doorstep, your career and your life to be torn apart. That is the reality of casting your thoughts into the social media forum today. But the fragility of this risk cannot be used to diminish the impact and hence the responsibility that must be held by users who can reach millions around the world in seconds. The ease of posting cannot be allowed to dilute the seriousness of the impact. So I return to my earlier argument. I invite us to replace posts on social media in this petition with words in a national newspaper or speech on national television. Would there be the same uproar or calls for clemency if a journalist or TV presenter had urged their audience to set fire to hotels full of people? I would suggest not. In the case of Lucy Connolly, her post inciting violence against a hotel full of people as riots raged around the country was seen by more than 300,000 people in the 3.5 hours before it was deleted. Roughly the same number as the combined daily circulation of the Daily Telegraph and the Times newspapers. To treat social media differently to incendiary violence elsewhere is something I cannot agree with. 9,000 followers viewed more than 300,000 times in 3.5 hours. We cannot keep pretending that what happens online stays online. The digital world is now shaping how people think, speak and act. The consequences of this are now impossible to ignore. The very power that social media holds is exactly why so many people wield it with such vigour. And let's not forget that it's a nice little earner for some too. The member for Great Yarmouth himself has earned over £40,000 from Twitter since his election, showing the huge potential of the site and potentially why he is incentivised to defend people's rights so enthusiastically to say inflammatory and shocking things to drive engagement, clicks and views. The online world has become a place where hate speech, or as the petition puts it, opinion speech, is allowed to spread like wildfire. Too often, social media platforms shrug their shoulders and walk away from the responsibility of monitoring it. Or worse, they actively encourage disinformation. Twitter is the most obvious offender for this. For those that still do, I'm told that scrolling through the Twitter feeds feels like stepping into the Wild West. Abusive comments and dangerous posts are left to fester without consequence. A factual error is twisted and retold as the gospel truth before anyone has had time to draw breath. Communities are put at risk by conspiracies that proliferate like a virus. Twitter must be doing far more to tackle the surge of hate speech we see on our phones and tablets every single day. Since Musk took control of the company in 2022, Twitter has rolled back on safeguards designed to prevent misinformation and dangerous rhetoric. The same Elon Musk who suggested that America should liberate the people of Britain and overthrow our democratically elected government. Incidentally, in the US CBP guidelines for allowing non-citizens to enter the USA, if an immigration officer knows or believes that someone will be entering the country to attempt to overthrow the US government, they are inadmissible. I wonder if we applied that reasoning to Mr. Musk's next trip to our country, he might have complaints about his treatment. Free speech, but not without consequences. This is a foreign billionaire armed with his global megaphone, fanning division and calling for the overthrow of our democratically elected government. I think we call that treason here. We cannot allow tech oligarchs like this to set the rules for British society. Instead of allowing the world's richest man to decide what toxic content floods national conversation, the government must wake up and intervene. We Liberal Democrats are calling on the Minister to properly equip Ofcom so it can enforce tough regulation to clamp down on the spread of misinformation online. Online safety cannot rest solely on the shoulders of individual users, as algorithms push controversial content for views and shares. Legislation must be tightened to hold social media platforms accountable for the dangerous rhetoric they allow to thrive. Social media is simply the latest chapter in humanity's long history of communication and vectors for incitement, from clay tablets to the printing press to broadcast news. Because it is so accessible, it arguably needs more accountability from its users and operators, not less, as this petition proposes. Liberal Democrats exist to build and safeguard a fair, free and open society. We have always and will always stand up for freedom of speech. However, that does not mean there is no accountability for hate speech or speech that incites violence. Those using violence, racist abuse or hate speech must face serious consequences, and we do not support the suggestion in this petition that social media posts should be treated any differently to any other types of speech. Thank you.
Opposition front bench, Dr. Kieran Mullen.
Thank you, Sir Roger, and it's a pleasure to serve under your chairmanship. And I also want to thank the Petitions Committee for enabling this debate and the Honourable Member for Caithness, Sutherland and Easter Ross, I hope I said that right, for opening it. I'm also grateful to the Honourable Member for Great Yarmouth who launched and promoted the petition, as others have commented. I thought on seeing it, it was the first time I'd come across a petition from a member, and it turns out that it is the first time. And the number of signatories he has managed to secure shows that this is an issue of great interest to our constituents, and it's right that we, as elected representatives in Parliament, debate these matters. And I want to begin by talking about something which I think was not given sufficient focus in the debate, and that's to begin by talking about priorities and choices. Because police officers cannot and have never been able to investigate and solve all crimes all the time. and they will never be able to do that. So choices and priorities have always been at the heart of policing since policing was introduced in this country. And it's the opposition's position that we would rather the police officers prioritised catching burglars, car thieves, shoplifters and other violent offenders. And it seems clear to me that the public agree with that. It also seems clear to me that this is an area that the police, CPS and the courts are not always managing to get right all of the time. As always, we can't be led entirely by the worst examples, but inevitably public concern is rightly raised by them. I won't overly focus on this debate on individual cases, many of which have been well publicised and thankfully in the end often not taken forward, but as always it begs the question, what would have happened in those lesser profile individuals or less well publicised cases that the outcome may well have been different. So this is clearly an area that needs our attention. That's not to say that there should never ever be any restriction on what people can put online. We need to find a balance akin to the one that as a whole, though certainly not perfectly, I think we do manage to keep more consistent in what you might call the real world. The criminalisation of hate speech and incitement is not new. What has changed is the scale and immediacy of communication in the digital age. Social media allows anyone from a mobile phone to reach potentially millions of people within seconds, and their words are essentially permanent and traceable. Equally, it exposes individuals to a constant stream of content, often stripped of context, sometimes designed to provoke. And social media also strips away the manner and demeanour in which something is said, which is often key to the prosecution of these sorts of cases in the real world. We do have a responsibility to ensure that the law keeps pace with technology, but also that it remains fair, proportionate and grounded in common sense. Those who use social media to clearly and obviously promote hatred, threaten individuals or genuinely incite violence must not be able to act with impunity. But we must also ensure that sentencing reflects the seriousness of each case, that it distinguishes between genuine threats and offensive opinion, and that it maintains public confidence in both justice and the freedom of expression. The judiciary has discretion to consider the context, harm and intent behind each offence, and proportionality is key. Sentences must be transparent, consistent and seen to be fair by the public. We know that the vast majority of people in this country value free speech deeply, but they also expect accountability for those who cross the line into criminality. That balance is delicate and it must be protected. Social media has created new forms of harm, but also new forms of expression, and the justice system must navigate these new, novel complexities carefully. However, when the response appears to some to exceed what is necessary to deter or rehabilitate, it's right that Parliament examines whether the framework guiding such decisions remains appropriate. Indeed, there have been an increasing anecdotal reports of the police arriving in disproportionate numbers to arrest children, parents and older people who may have said the wrong thing, as they might describe it online. One example, widely reported in the press, involved the arrest of Graham Linehan by 5 armed police officers at Heathrow in September. His alleged offence was a series of social media posts in which it seemed apparent to most dispassionate observers he joked about punching a transgender woman in the genitals if they refused to leave female-only spaces. And I think there's a good example of the sort of speech we wouldn't welcome, the joke rather, that wouldn't be welcomed and many people would think was displeasing and inappropriate, but certainly should have been very carefully considered before putting forward as a possible crime. It's hardly worthy of 5 armed police officers' time. This use of police time and resource is completely disproportionate when officers' efforts could be focused on dealing with crime our constituents, as I've said, such as knife crime, shoplifting, burglary, that are regularly going unsolved, are not having the same level of attention in all circumstances. I welcome that in response, and I think in quite clear support of the fact that there is an issue here, that the Metropolitan Police have announced that it would no longer investigate non-crime hate incidents. So for those in the debate who seem to think there's no issue here, I would point them to that decision by an independent police force about a major change in how they were going to police these sorts of things. And as they said, to focus on matters that meet the threshold for criminal investigations. We now need to see this approach applied across the whole country, something that the Conservatives put to a vote at committee stage of the Crime and Policing Bill early this year, but the government sadly voted down. I'm also aware the National Police Chiefs Council, supported by the College of Policing, has reviewed the use and effectiveness of non-crime hate incidents. Subsequently, the MPCC and the College wrote to the Policing Minister in September, urging her to immediately scrap non-crime hate incidents in their current form. But I'm afraid the government hasn't acted. It's ignored the authors of the review that it self-commissioned and kicked the issue into the long grass. So can I ask, as one of my questions, the Minister whether he'll work with the Home Office to implement the recommendations of the MPCC and the College of Policing? More broadly, I'm afraid the government is also not being transparent about this issue. The government does not collect data on non-crime hate incidents. It also does not publish data on the number of arrests made for online malicious communications offences. Therefore, accurate quantitative data on arrests and prosecutions for offences on social media are hard to come by. I would therefore like to ask the Minister whether he agrees with me that the Government should do more to assuage concerns by collecting and publishing data that might help illuminate this issue. We do have some data. That's because in April, The Times published an article using data collated from FOI requests, setting out the number of arrests made under Section 1 of the Malicious Communications Act and Section 127 of the Communications Act in recent years. The newspaper reported that police officers are making over 12,000 arrests a year under legislation, equating to over 30 a day. And I remind members about this issue of priorities, that there are police officers going out and making 12,000 arrests a year for these sorts of offences. They also claim that the number of arrests in 2023 represented an almost 58% increase since before the pandemic. It said that in 2019, forces recorded 7,734 arrests. Yeah.
Thank you. And I'm really sorry to interrupt you something up. You're doing a great job. But these numbers do invite some further investigation. So it does sound like quite a lot of arrests, 30 per day. But for how many of these was that the sole reason for arrest? Or was it just a matter of there were many other factors all combined together and that was just one point in that arrest schedule?
I think that's a really good example of the sorts of questions we can't answer, because what we've had to do is rely on media organisation to put forward some FOIs to get some sense of information, whilst actually the government was taking ownership of this issue and publishing proper data that might be able to pick out those nuances. We could have a much more realistic debate, because you're absolutely right, that could be the explanation here, but we're none the wiser. And so I would like also to say that I don't think we can simply lay the blame for this spike with rank and file officers. They are often only following orders from their superiors who point to guidance from the MPCC and the College of Policing. And while this is happening and potentially people are receiving prison sentences, and this is another key issue, I've spoken to very many people who perhaps thought that people like Lucy Connolly had done the wrong thing and should be punished, but were very concerned about the length of the prison sentence. At the same time as the government won't budge on this issue, they are passing legislation right now in this House that will let out thousands of violent sexual offenders out of prison earlier. Very many, thousands of them, will serve only a third of their sentences because they say that there isn't enough prison space, and yet the proportionate response they also say is that we have plenty of prison space to arrest other people. I'm happy to take an intervention.
Yes, thank you. Would the Shadow Minister recognise the fact that when his government were letting out rapists and violent criminals, they put no protections on whatsoever, whereas this government has brought in protection orders and domestic violence orders to make sure that those people who are victims are actually protected in these cases, and that the prison crisis was caused under his government.
I have to say I genuinely welcome that intervention, because throughout the debate of the sentencing bill, again and again, Labour MPs make interventions that demonstrate they fundamentally do not understand the bill. So if I take you through step by step, I will. So, well, it's just an explanation. It may come from a man, but it's just an explanation. So the early release schemes that we used and that your minister previously, the minister was previously using, excluded all sexual offences. So we excluded sexual offences, and the continuation of other early release schemes excluded sexual offences. The sentencing bill makes no exclusions for sexual offences. None. So we wouldn't let out rapists earlier, and your government initially, the Labour government initially wouldn't let out rapists, but you're now going to do that. We wouldn't let out people that raped children, and then initially your government wouldn't let out, the member's government wouldn't let out people who rape children, but you're now passing a bill that will let out people that rape children. And when people say it's about a short-term crisis, again, there are existing schemes that you can continue to use for short-term prison capacity issues, the ones that I've talked about that exclude sexual offences, that we would both agree should be excluded. Instead of carrying on using those schemes, this government is legislating on a permanent basis to let rapists, child rapists, paedophiles out of prison earlier. 90% of people that go to prison for child grooming will be serving a third of their sentence. If that's something that member opposite thinks is defendable, I encourage you to go away and read the detail. But I'll continue. As I said, the sentencing bill lets out thousands of violent and sexual offenders, even if members opposite pretend that isn't what's going to happen. And I would also just point out there are Labour MPs who understand this and who wouldn't vote for it. and understand what you're being persuaded to vote for by your government in a way you really shouldn't, that they shouldn't. So I'll continue. The Minister, I hope, will commit to looking again at the sentencing framework to ensure it best reflects the concerns that colleagues have laid out today. Otherwise, this is a missed opportunity. We are clear that we can only restore democratic accountability to sentencing through the abolition of the Sentencing Council and the restoration of its activities to the Lord Chancellor's Office. That's the sort of wholesale reform that's needed. We introduced legislation to enable this in the Commons when considering the sentencing bill, but Labour voted it down. They proposed a halfway house that won't really achieve anything like the radical change we need. So the right choices are there, a better way forward is available. Yes, this is a new area for our law, this is a new area for society. Maybe we were always going to take time to get this right, and I welcome the campaigners and individuals affected, driving politicians of all parties to do so. We have some clear proposals for reform which are a start, but in the meantime, sadly, I think it will take more cases, more public concern and more demands for change to the government to get this right. Thank you.
Minister, Jake Richards.
Thank you, Sir Roger. It's a pleasure to serve under your chairmanship. We're here to debate whether to review the penalties for social media posts as put forward by the Honourable Member for Great Yarmouth. And freedom of expression is a cornerstone of our democracy, but so too is the right of every citizen to live free from abuse, intimidation and harm. And a government's role and Parliament's role is to uphold both, to protect rights and responsibilities online and offline. It has long been a principle in this country that people are free to express their views, even when those views are uncomfortable, unpopular or challenging. They may indeed be offensive, but we must also recognise that freedom of expression must be balanced against the need to uphold public safety and to ensure that our laws are equipped to deal with the realities of modern communication. That balancing act is not set in stone or fixed, but is a constant challenge for our society, as it should be. Any tension or conflict between these principles must be carefully considered and monitored, and this debate plays a role in doing that. It's an important one, and is symbolic of that debate, and I welcome all contributions from all different perspectives to it. Absolutely.
I thank the Minister for giving way, and I will always defend freedom of expression, but one feature I am concerned about is the proliferation of disinformation content online, particularly by hostile states designed to divide us and undermine our democracy. I wonder if the Minister will comment on that and what approach the government will take to tackling that and enforcing that as well.
Absolutely. My humble friend makes an important point, and technology and social media has become more complex, more difficult, but that doesn't mean we mustn't shy away from attempting to ensure we protect the principles that we hold so dear, including democracy. And I'm coming on to dealing with some of those points later in my speech, but it's a very important point. This government is committed to ensuring penalties for these types of offences are proportionate and uphold freedom of expression. Sentencing is and must remain a matter for the independent judiciary. We all have a responsibility, and government ministers in particular, to take extreme care when discussing individual cases, and I will not be commenting on any, even if, of course, we all take our own personal views on cases which catch the public imagination. But a sentence in the court of public opinion is not as rigorous as those imposed by courts of law. Each case is different, and the full circumstances are often not reported widely. Media stories of cases rarely convey all the information which the court had before it when deciding on the sentence. Where an individual is convicted for an offence related to online speech, the independent judiciary are responsible for determining appropriate sentences based on the facts of each case and the relevant sentencing guidelines. An independent judiciary is vital to the rule of law and to the functioning of a democratic society. It ensures that justice is administered fairly, impartially and critically without political interference. The independence of our judiciary, away from political influence, is a vital part of our constitution. I, for one, am determined to protect that in my role, and the proposals by the opposition to simply scrap the Sentencing Council amount to simply constitutional vandalism, have been described by previous Conservative Attorney Generals as completely absurd. Absolutely.
Does he accept that the proposals we put forward, which are not just to abolish the Sentencing Council but to create a number of bodies that advise the department, are exactly essentially the proposal that existed before the Sentencing Council was introduced by the Labour government? Did he think there was constitutional vandalism prior to Labour's reforms?
The Honourable Member, in fact, is completely incorrect. What the Conservative Party are proposing at the moment is not what was happening before the Sentencing Council. They are trying to bring within the executive the sentencing of how we sentence every single type of criminal case. That is a completely new, innovative and wholly dangerous proposal which has been completely criticised by Conservatives themselves I remember when Conservatives used to stand up for our Constitution, who used to stand up for the separation of powers, not simply follow the populist flame. The sentencing framework is important because it provides courts with a range of sentencing powers to deal effectively and appropriately with offenders in addition to imprisonment, including discharges, fines, community sentences and suspended sentences. The law also makes clear that imprisonment should only be imposed as a last resort and where no other sentence would be appropriate. When deciding what sentence to impose, courts must consider the circumstances of the case, including the culpability of the offender, the harm they caused or intended to cause, and any aggravating and mitigating factors. They have a statutory duty to follow any relevant sentencing guidelines developed by the Independent Sentencing Council for England and Wales, unless they are satisfied that it would be contrary to the interests of justice for them to do so. Differences in sentencing outcomes will therefore be the result of a number of factors, including whether the offender has previous convictions or whether an early guilty plea was entered, as well as any particular aggravating and mitigating factors. They may also include circumstances surrounding the offence, as well as circumstances personal to the offender. It is right that courts have the discretion to consider these factors and to tailor sentences accordingly. But that does not mean, and none of my argument should give the impression, that sentencing is not subject to democratic accountability. Parliament is sovereign. The sentencing bill which we are taking through the House currently makes new changes to ensure that the Lord Chancellor and Lady Chief Justice must agree to new guidelines before they come into effect, a new mechanism for bolstering that accountability. We do not want politicians handing down sentences on each given case, leading to wild inconsistencies and unfairness. But of course, sentencing has a democratic function, and this change, in my submission, strikes the right balance. The government commissioned a comprehensive review of sentencing powers through the Independent Sentencing Review, chaired by the previous Conservative Lord Chancellor David Gauke. This was wide-ranging and evidence-led that examined the full spectrum of sentencing options. The aim of the Independent Sentencing Review was to ensure that the framework is robust, proportionate and fit for purpose. And the review was guided by three core principles. Sentences must punish offenders and protect the public. Sentences should encourage prisoners to turn their backs on the life of crime. And we must make greater use of punishment outside of prison. The government accepted the majority of the review's recommendations in principle, many of which are now being delivered through the sentencing bill, which is currently progressing through the House of Lords. Our focus remains on ensuring that the justice system protects the public, upholds fundamental rights, and uses custodial sentences only where they are necessary and proportionate. The government have made it clear that we need to focus our law enforcement efforts on preventing crime in our communities, more police on our streets rather than more policing of our tweets. But the government does not feel there is any case for a change in legislation at this stage as proposed by the Honourable Member for Great Yarmouth. Freedom of expression is a right that must be protected, but it is not an absolute right. It carries a responsibility to use that freedom honestly and decently. Freedom used irresponsibly corrodes democracy. Responsibility without freedom weakens it. Our job, the government's job, is to protect both, and the Online Safety Act and our wider sentencing framework reflects that balance. They are designed to protect individuals, uphold justice, and preserve the freedoms that define our society. The Act has been designed to safeguard legal free speech, uphold privacy, and support innovation. The Act does not prevent adults from accessing legal content, nor does it restrict people from posting content that others may find offensive. The Act involves the regulations of systems and processes that platforms have in place for tackling illegal content and, critically, protecting children. There are also protections against the over-removal of content where platforms take down content they should leave on their sites. As use of the internet has expanded, there has been an increasing awareness that online content and activity can cause serious harm to users. From disinformation to targeted harassment, what happens online now shapes lives offline. The public is right to expect protection online from abuse that would never be tolerated on our streets. There are some circumstances where the criminal threshold is met for genuinely harmful and dangerous material, whether that be online or through other forms of communication. That is why the Online Safety Act introduced 3 modern communication offences: harmful, false and threatening communications, ensuring our legal framework is fit for the digital age. And we have now seen that new offences introduced by the Act are being used proportionately and effectively. Earlier this year, an individual was convicted under Section 184 for encouraging a child to undertake serious self-harm through online grooming, the first case of its kind, and we've heard about the real dangers online for children that we must clamp down on. This demonstrates the importance of having modern digital age offences capable of protecting the most vulnerable from genuine life-threatening harm. The Act also delivered Zach's Law, named after a young epilepsy campaigner, which rightly makes it a criminal offence to send malicious flashing images intended to trigger seizures. This is a clear, common sense and compassionate example of how the law can evolve to protect people with disabilities from cruelty and real and demonstrable harm online. And we should remember that the Online Safety Act is not the only legislation that can lead to custodial sentences for online speech. Recent convictions, including that of the individual jailed for issuing death threats against the Honourable Member for Clacton, show that existing laws on threats and harassment are being applied robustly where speech crosses into criminal intimidation. Democracy cannot function when intimidation replaces debate. That is the balance we seek to strike between regulating an increasingly influential online world to protect the public and between freedom of expression and the safety of individual and communities. I thank all members for their contribution. This is an issue that not only is important to this House, but clearly to many people across the country. And it is vital that we allow and indeed encourage rigorous debates about the relevant legal framework. Thank you, Sir Roger.
Jamie Stone to wind up the debate.
Sir Roger, thank you very much indeed. As colleagues are aware, any chairmanship of a select committee is elected by the House. And therefore, on this occasion this evening, I'm rather more the servant of the House than the party. So I speak, as I should be as chair of the Petitions Committee, I hope impartially. I think that we have had some verbal jousting in this debate, Sir Roger, but that's no bad thing to air an issue out in the open and in our democratic forum. And I, in particular, want to thank all the members who've spoken. I thank the petitioner himself, the Honourable Member for Great Yarmouth. It is indeed a historical first, this one. This has never happened before that I'm aware of in the history of this place, that the petitioner is a member. So thank you, Sir Roger, to yourself, to all the members who have spoken. And I want to thank also the members of the public. I don't know how the members of the public feel about this, but I felt a rather chilly draft at my back. And I think we ought to offer the Parliament a shilling for the metre. We'll just turn the heating up a wee bit. So I thank the members of the public for coming as well, and you've witnessed something I think we do rather special in this place. Thank you.
That this House has considered E-petitions 728-715 relating to penalties for offences arising from social media posts. The question is, as many of that opinion say aye? Aye. Contrary, no? Ayes have it. Order, order. Sitting suspended until 6 p.m.